The following program is made possible in part by the Dayton Bar Association.
Good evening and welcome to this month's session of You and the Law. This is the second month that we're coming to you via Zoom. We've worked hard collectively to try and work out the kinks, if any. I encourage you to call in. You're familiar with the format, and I'll talk about that briefly if you're not. But we encourage you to call in and ask questions during the show. The show is brought to you, is underwritten by the Dayton Bar Association, located in downtown Dayton, Ohio. Phone number 937-222-7902. Particularly important if you have need of an attorney, you can reach the Dayton Bar Association at that number and ask for their lawyer referral service. The show is produced by DATV. You can go to DATV's website, datv.org. There you will be able to see the show being live streamed this evening. If you have Spectrum TV and live in the northern suburbs of Dayton, actually throughout Dayton and Butler Township, you'll pardon me for reading some of this. I don't have the cue cards or any teleprompter here, so these are my notes. I hate to read to you, but Channel 5, this is live tonight in Dayton, Butler Township, and Riverside. Channel 6 in Dayton's northern suburbs. This will then be rebroadcast starting, I believe, next week. If you live in the southern suburbs, on the Southern Public Access Television Station. And the times will be in accordance with their schedule if you go to their website. This is a show this evening on the Nuremberg trials. I'm very happy and pleased to have Professor Dennis Turner, Professor Emeritus from the University of Dayton School of Law. Professor Turner was with us last year to discuss a book that he had written about the experiences of a quasi factual group of nuns during World War II and how they worked with the resistance in the underground during the war, and the challenging issues there that had throughout the time that they worked with the resistance, the underground, how they managed to try and keep true to their vows while also doing great work to help save lives throughout the war. Tonight, Dennis is going to be speaking with us about the Nuremberg trials, which took place after World War II. I'm not going to say too much about this now. I'm going to let Dennis set the table and tell you he's done a great deal of research on this subject matter. I think it's one of great import, and eventually I'm sure we'll get into some discussion about the question of what have we learned from those trials, what have we learned from this experience, if anything. And so without further discussion here, I will tell you only that there will be a number that comes up on your screen during the trial, 937-253-5311, 937-253-5311. That will be the number for you to call in live. With that said, Professor Turner Emeritus, good evening. Welcome.
Hi, Jeff. Thank you for having me.
Well, it's a pleasure. It was a pleasure last year, and of course, it's a pleasure again to have you this evening. So tell us. Let's get started.
So first of all, I'm going to give a plug for the book. The name of the book is "What Did You Do in the War, Sister?"
Okay.
I'm not embarrassed by doing that. Anyway,
Okay.
So
Dennis,
please do-
excuse me a second. I've lost you. There, I'm back. Okay.
we'll lead into the Nuremberg trials. A little background, of course, is the war itself ran from 1939 to 1945. The trials began in 1946 and ran to 48, a little bit into 49. So in a way, we're on the 75th anniversary of the Nuremberg trials. So during the war, even back in as early as 1943, there were serious discussions among the Allies, especially the Russians, the British, and the Americans, about what they were going to do. They were assuming they were going to win the war. It was still in 1943. And the question, what are we going to do with these Germans who have perpetrated all these war crimes and other things going on? And that incentive only became greater as liberation of particularly Germany took place, and and Poland, and the discovery of the concentration camps and what was going on in the concentration camps. So the desire to do something about the people in Germany, especially the leaders, for perpetrating these kind of crimes. The Churchill and Stalin actually sort of agreed on what they wanted to do. They basically said, let's round them up and shoot them. Just round up all these Nazis and the leaders that we get our hands on, and we'll just shoot them. The Americans, particularly the Americans, thought that this would be an opportunity, that there should be a trial they should be tried, and that in a sense the rationale was to make a record of what they would do, establish for history what actually happened, so that nobody in the future, if it was done right, would have any doubts about what happened during that period, particularly the war crimes and the Holocaust and all of that didn't want anybody later on, although ironically we still have Holocaust deniers, they didn't want people to later say, oh, well, that didn't really happen. So that was one of the goals. I think there was an altruistic goal of the idea that somehow, if we do this and we make the waging of aggressive war an international offense that could be tried in an international tribunal, that we might have an impact on the declaring of war. But I'll talk about that one of the four charges later on. Yes.
Yeah. I think that's particularly important because that from the outset, that was a major topic of discussion. And at the end, when it was all over, and in the succeeding 75 years, that's been an ongoing source of the discussion, right?
Yes. And of all the elements coming out of Nuremberg, that is one that has had the least, almost non-existent impact on aggressive wars. As you know, there's been a lot of aggressive wars waged since the end of World War II. So then there were four others, and I'll talk about the four charges that were brought. So the question then became of a debate mainly between the British and the Americans and the Russians. Now, the French were allowed into this, but there was a lot of controversy about letting them in. Why the French? One, they gave up. And two, they cooperated with the Nazis. They made a deal with the Nazis, and a lot of their own Jewish population, they facilitated transport to concentration camps. So the issue of why should the French even be involved was resolved with having them there, but that was an issue. So the main argument was between the British and the Americans and the Russians, and that was, what if we're going to have a trial? What kind of trial are we going to have?
May I ask you a question?
Yes.
A quick question, since you're getting into this particular point. I had read, trying to prepare for this evening, that there was some debate between Churchill. Churchill was very quick to want to shoot and ask questions later. And that the Russians actually had the nerve to say, Stalin said, oh, in Russia, we always have a trial before we execute anyone.
Yeah.
Is there any truth to that, or did they really?
I think they were both basically saying the same thing. The Russian trial is one that the Russian representative at the Nuremberg trials presented in terms of the process. They said, well, we know they're guilty, so we put them up and we say you're guilty, and now the only question is, what's the punishment? You know, there was that kind of trial, I guess, so there may be some mitigating thing, but it's clearly a show trial, and we have seen examples of show trials in Russia and other places a lot, and it, somebody stands up and they're harangued, and maybe they'll usually make some kind of statement and then say you're found guilty, and then you're taken out, shot, or whatever. So that was kind of the Russians' idea. So then, but the Americans and British wanted a full trial with a representation for the defendants and proof beyond a reasonable doubt that they committed, and would entertain the prospect that the defendants could be found not guilty. Well, the Russians were very hard about that, and because they had 20 million people killed at least, and so they was wondering why in the world we should give any kind of break to these Germans who perpetrated all these crimes. And so, but the Americans had a card up their sleeve of sorts, and Jackson played it in the end, and got the Russian cooperation. And what he did is he said,
will you go on to also talk about who Jackson is?
Okay,
briefly.
Justice Jackson was the lead prosecutor for the U.S., the American side. Justice Jackson took a leave of absence from the Supreme Court.
United States Supreme Court. He was an associate justice.
To take this position, and quite a career, or almost a dangerous move for a Supreme Court justice, if you think about it, is that you've been doing appeals, and now they're going to throw you into the courtroom, and you're going to try a case, one of the most significant cases ever tried, and now you're back in the courtroom. So there will be some issues about his trial skills that crop up during the course of this. But at the beginning, they were insistent on having a full trial with cross-examination and again, a pretty fairly typical American British trial, except that it was going to be tried to judges. There would not be a jury. So the Russians were insisting on what they wanted, and Jackson pointed out to them, he says, well, maybe we'll just do separate trials. You try the Nazis that you have in your power, and we'll try the Nazis that are in our power. Now, of course, the irony was, of course, the Russians had a couple of minnows, and all the biggies were under the American and the British jurisdiction. Goering, Hess, Kaltenbrunner, all of them were there. So the Russians, folded, and they said, "Oh, okay, I guess we'll go for a trial," because they were going to be cut out of the big trial otherwise, so they could do it on their own. So that was an initial discussion about the nature of the proceeding. And then they had to pick a location, and they ended up deciding on Nuremberg for a number of reasons. One, of course, Nuremberg was like one of the centers of the Nazi movement. All the big rallies and everything that you would see on the newsreel with those hundreds of thousands of people out there, raising their hands to Hitler, took place in Nuremberg, in the Nuremberg Stadium. So it was a big Nazi deal. So this seemed, I suppose, some poetic justice to bring those same Nazis into Nuremberg and to try them in the Nuremberg courthouse. And as a practical matter, it also turned out to be a good physical location with regard to the courthouse itself. The courthouse was one of the few buildings that actually survived the bombing.
Right.
And it was the main courthouse for many of the trials that the Nazis had that were really more show trials of their citizens. And so there had that aspect. And then, but it was big, and it was connected to, it had huge underground cell blocks. So they could keep all the defendants right there in the courthouse. They wouldn't have to move them through the streets to the courthouse. So it had all those advantages, and including a facility to hang people if that would happen. So that was the sort of historical background to this. And the thing that stands out about these trials is this was entirely a new area of international law. This has never been attempted before. Usually, I mean, the victors, if they were the victors, they usually took it out on the losers. And so you just round up the bad guys, and you had drumhead trials in the military courts, and then you execute them. There was not much to be said. So it was never done. Now, so a lot of times leaders weren't even prosecuted. So if you think about the Germans after World War I, they had a lot of atrocities in Belgium and France. Nobody ever thought about bringing them to trial. The leaders often escaped of countries who, no matter what they did, we just wasn't going to, we didn't prosecute them. There was no mechanism for prosecuting. So the thought was that if we actually have a trial, or if we didn't have a trial, there would be no deterrent for future bad actors. In other words, people who launch into these things always think they're going to be on the winning side. So it's not going to impact their behavior because they are assuming, oh, we'll be the winners. So it doesn't make any difference. And so that's not, the fact that you might get tried is not really, or be held accountable is not really that deterrent, because winner takes all in these situations. I think they were also concerned, again, in sort of ensuring that no myths or martyrs were created that could then be used to justify a later war. I think in World War I, that was the case, in that the myth started to go around that the German army wasn't really defeated, and it was just a backstabbing of the Jewish people and others that kept the German army from winning, and so that sort of mythology was a big underpinning for the Second World War, and gave justification, or at least a fig leaf of justification staging of the Second World War. Of course, the Versailles Treaty imposed a lot of obligations on Germany that caused a lot of pain. So they had to provide the accused with a fair trial, in some way more than a fair trial, because they were being judged by history. They wanted to make sure that this was a fair trial and that the record that was established in this trial would be definitive for all time. And so they wanted, a factor, I think, a big goal here was they wanted the world, and especially the German people, to see that their leaders were very bad people and that their actions weren't worthy of the German people. And they wanted to send a message to potential perpetrators of war crimes and genocide, even against their own citizens, that they couldn't escape punishment. Because again, historically, you could do whatever you wanted to your own citizens, and the international community would not intervene. So this was, again, breaking new ground in which the international community would actually prosecute people who were committing crimes against their own citizens. And that certainly was new ground. So,
may I ask you this at this juncture? Weren't there some limitations? And again, as we talked prior to the show, I'm dangerous because I did some reading here to update my knowledge. But there were two primary limitations on the defenses that could be offered relative to I did it because I was told to do it, and B, well, you did bad things too.
yeah.
And it's my understanding that those defenses were not, as a general rule, allowed, notwithstanding what you have said thus far about the nature of the trial and so forth. Now, I don't know if that's accurate or not. That's one account I read that I found interesting.
No, well, those were raised. One of the defenses, particularly not of this group. In fact, I have a slide of this group that I will share. Can you see that?
I can see it.
Okay, these are the defendants in the dock in the first trial, and they're along here, along the panel there, with the Goering on one end and Hess and the whole group. There were 21 defendants. 22 had been charged. Martin Bormann had been charged, but he was being tried in absentia. One of the
who is in front of them?
These are all their attorneys.
Oh, their attorneys. Okay, I knew that. I just wanted to identify them. Okay.
They had some really very well-known Nazi attorneys, but they suffered a little bit because they weren't used to Anglo-American law procedure. So I mean, they were outstanding German jurists, but they were not that skilled in terms of the give and take of an American or British trial.
And that was the major crimes group. There were four groups, right? The major crimes, war crimes group, the trial that you'll talk about against the judges, doctors' trials, and then these mobile killing unit defendants.
Yes, but there were a lot of other trials going on of lesser folks.
Oh, you want to talk about that or not?
Yeah, well, I'll be dealing. I got a little video with, or not a.
Oh, okay.
A little.
I'm jumping the gun here.
A schematic on that.
Okay.
But so at this level, I was just following orders defense doesn't really work because they were the leaders. I mean, unless
Right.
you say Hitler gave me an order and therefore
Right.
I had to do it. And that doesn't wash so well. A soldier, an SS soldier, told to, well, shoot these prisoners, has a little better stance on that. But even I was just taking orders defense doesn't fly even for the military, because over international law, you were able to ignore or not follow through on an illegal act. In other words, some act of that. Now, of course, that's easy to say in the abstract if you're a soldier and you get shot at, you to others. But that defense has never worked. They tried it in the My Lai massacre case. Doesn't fly. In fact, in the U.S. military, in the booklets that they have out, it says you are not obliged to follow an illegal order. In fact, you're obliged not to. So, I mean, it's at least technically there. So these are the 4 counts of the charges. The first one is conspiracy to wage aggressive war, and that dealt with the activities prior to the war in which they were conspiring to wage the aggressive war. The premise being that the Germans were preparing to do this all along, and they were laying the groundwork for that, including the persecution of people in their community, the communists and the Jews. That was all prep for their aggressive war. Then the next count is conspiracy to actually wage aggressive war. In other words, they launched the war and in violation of the international treaties and agreements. So they actually go to war, being another count. And then conspiracy to commit war crimes, and that is what they were doing in the prosecution of the war, violation of the laws of war, including prisoners of war, slave labor, and those kind of things. And then finally, so much of this is breaking new ground, but this one is definitely breaking new ground. Conspiracy to commit crimes against humanity. Totally never done, used before. And what this enabled them to do, at least ostensibly to do, and what they ultimately did do, was that they could charge the Germans for what they did to their own people. And so that involved actions in the concentration camps and other death rampages against both German people and other nationalities, crimes against humanity. That was a watershed as far as how it went. So you're probably going to wonder what this is. That's an amoeba. And to me, I thought that this is a good example of the legal theory that the Allies adopted to try this case against these 22 defendants. And if you think of the amoeba as being this organization that is out, and amoeba eats everything around, destroying everything around, but there's a lot of parts to the amoeba, and they don't do the eating necessarily, but they're supporting the activities of the amoeba. So you might say that the amoeba has kind of there's a conspiratorial aspect to this group, in which the conspiracy is to eat their neighbors. So that is actually the glue, the conspiracy glue that holds these charges against these 22 together. Because you have this odd circumstance in that you got people like Goering, who was Hitler's successor, you have a radio announcer, Fritz, you have a PR man in Hess, you have a banker got a newspaper publisher, you got an admiral, you have the head of the SS Kaltenbrunner and the Gestapo, and you have this group of people, all of them did different things. You can't say that a radio announcer perpetrated the conspiracy to launch an aggressive war or a crime against humanity. He's a radio announcer. You know, he didn't do anything. But the conspiracy glue says all of you from the very beginning bought into the Nazi propaganda, the Nazi, and you knew what Hitler had in mind. You knew what was going to happen, and you bought into this. You were part of the conspiracy, and you worked to further that conspiracy because you were part of that conspiracy, and therefore you're equally guilty. All right, you didn't run the concentration camps, but you facilitated in many ways the concentration camps and the deportation of Jews and all that. You facilitated that, even though you were just a banker or a newspaper publisher. The other thing they did, which was quite different, is they indicted organizations like the Nazi Party, like the SS. They actually charged the organization with these crimes. And not just these individuals, but the organization as well. And the idea was, again, rather revolutionary, is that, okay, these folks are not just the only folks committing atrocities. I mean, there's a whole lot of people involved with committing atrocities, down to the concentration camp guards, for example. How can we possibly prosecute those, 250,000 people or something? How can we possibly do that and have trials? Well, again, the conspiracy glue enables them to do that, because if they've indicted the Nazi Party and the SS, for example, that means all they have to show to get at least a prima facie case against these individuals is that they were a member of the Nazi Party or the SS. And so here we have Pete, Mary, or Joe, and we prove that you were a member of the SS. Therefore, you are part of this conspiracy, and you supported this conspiracy. Therefore, you have criminal liability. Now, what you actually did or did not do may mitigate what your penalty. In other words, you may only get to have to go be denazified, or you may serve a year or something, but you can't escape because you were a member of the SS. You knew you were part of this conspiracy all along. So that was the as I say, the glue that held that together. And just as an aside, you asked about Justice Jackson's background, which I find quite intriguing in the sense that if other people followed Judge Jackson's route, we law professors would be out of a job because he was on leave of the Supreme Court and he was appointed by Truman. Justice Jackson never went to college. He did not have a college degree. He had 1 year of law school, and then he did an apprenticeship and became a lawyer, and ultimately on the Supreme Court, and one of the outstanding jurists on the Supreme Court in terms of knowledge of constitutional theory and that. So, as again, he didn't need a law degree. So, but I'm glad that's not the ordinary route. So, this is Justice Jackson's opening comment, opening remarks. Considered, well, I'll let you evaluate it for yourself. Skip ahead here.
May it please your honors. The privilege of opening the first trial in history for crimes against the peace of the world imposes a grave responsibility. The wrongs which we seek to condemn and punish have been so calculated and so devastating that civilization cannot tolerate their being ignored because it cannot survive their being repeated. That four great nations, flushed with victory and stung with injury, stay the hand of vengeance and voluntarily submit their captive enemies to the judgment of the law is one of the most significant tributes that power has ever paid to reason. If these men are the first war leaders of a defeated nation to be prosecuted in the name of the law, we agree that here they must be given a presumption of innocence. We accept the burden of proving criminal acts and the responsibility of these defendants for their commission. We have no purpose here to incriminate the whole German people. Hitler did not achieve power by a majority vote, but seized it by an evil alliance of revolutionists, reactionaries, and militarists. You will hear today and in the days ahead of the enormity, the horror of their acts. Prosecution will give you undeniable proofs of these incredible events. I count myself as one who received during this war most atrocity tales with suspicion or skepticism. No more. The catalog of crimes will omit nothing that could be conceived by their pathological pride, cruelty, and lust for power. You will hear of the repression of organized labor, the harassment of the church, persecution of the Jews, the conversion of mere anti-Semitism into the deliberate extermination of the Jews of Europe. You will hear of the long series of German aggressions, conquests, and broken treaties, the terror that settled over Germany, the havoc wrought in the occupied territories. And you will know that the real complaining party at your bar is civilization. Civilization asks whether law is so laggard as to be utterly helpless to deal with crimes of this magnitude by criminals of this order of importance. It does not expect that you can make war impossible. It does expect that your juridical action will put the forces of international law, its precepts, its prohibitions, and above all, its sanctions, on the side of peace, so that men and women of goodwill in all countries may have leave to live by no man's leave underneath the law.
So I guess I should give credit to that. That is from the movie Nuremberg, and you know that was Alec Baldwin there playing Justice Jackson. It is not a great movie in the sense of cinematography. They do a lot of stuff that kind of bother them. But the thing that makes it a really good movie is almost all the trial scenes in that movie use the actual dialogue or actual testimony that took place and the statements made in the courtroom. So that speech is verbatim what Jackson gave in the opening of the trial. So yes.
Before you move on from those movies, unless you were going to discuss them further,
No.
it's my understanding that the one movie was indeed based upon these transcripts, and the other, and a broader group of defendants, whereas the other movie focused on 4 judges who were the defendants.
Yeah, well, actually 5 judges. Judgment at Nuremberg is a much better movie. Not as historically accurate as regard to what was actually said sometimes. Uh, that was what I would call more Hollywooded up, but a much more powerful movie and a better movie all the way around. But because the trial of the judges had to proceed on a different theory of the case, the conspiracy glue that held these together didn't go for the judges. They actually had to prove that the judges committed the crimes. They were basically almost charged with common crime in the sense of being abettors of the policy of the Nazis to exterminate Jews and Poles, and the Poles were sort of in that category as well, and so they facilitated that, and so they were kind of like the abettors of a crime. The same as if you give somebody a gun and to rob a bank, and they go in and rob the bank, and they shoot somebody, you're equally liable for the homicide as well. The other thing that, and I think was a big issue in this trial, was this ex post facto aspect of it, in that these individuals were being charged with crimes, and again, this had never happened before, to bring these people to justice, and they could say, well, wait a minute, you're just making up the law now, and you're charging me with a law that didn't exist before. It's like one day on Route 35, there's a 60-mile-per-hour speed limit, and you go 60 miles, and the next day they have a 35-mile-per-hour speed limit, and then they charge you with speeding for the day before. That's ex post facto. It's after the law was made, and they tried to make that case. And the riposte to that was that there was law. There was a lot of international common law out there about the laws of wars, and a lot of those was out there. You were on notice that those laws existed. Now, you weren't on notice that you would necessarily be prosecuted for them, but you knew the laws were there. Geneva Convention, Calais-Briand Pact, all those things were there, and you violated them. So it isn't ex post facto. Those laws have been around for a long time. So that's how they got around it, by kind of creating an international common law. You violated international common law, and now we're going to prosecute you for it.
And in a sense, they could almost do whatever they wanted. I'm just speculating on this. They could do whatever they wanted, those who were making the rules, but they had the whole world watching what they were doing.
You mean they, meaning the tribunal, or the?
Yes. Well, those who set this up, okay, particularly amongst the Allied nations, those who set this up, it set this forum up, this method of charging, the types of crimes more particularly, and so forth. But there was a certain accountability here, wasn't there? Broader than just guilt or innocence.
Yeah, well, that was the transparency of the trials went on for 10 months, and the documentation was overwhelming, because the Germans, being Germans, were so precise and particular. They documented everything, every little detail. And so you had this wonderful opportunity as a trial lawyer you would love to have. You have all these documents written by these folks, and as soon as they say, oh, well, I wasn't involved in that, you pull out a document and you say, is this your signature on this letter? Well, yeah, but look what this letter says, and they could just do that over and over again. And so it was the trial by documents, by and large. And I think that was Jackson's strategy for history and for making the case. The problem, of course, is it lost the news buzz when you didn't have live witnesses. And this was part of a big debate between General Donovan and Jackson, and Donovan actually ended up leaving the team. He wanted live witnesses and to do more live witnesses, because if you're a trial lawyer, if you were just trying this case to a jury, you'd want some live witnesses, right?
Sure.
You want that excitement. So they ended up putting on some live witnesses with regard to the medical stuff, and also a lot of the concentration camp and other kinds of things. So they put on live witnesses to sort of get the attention of the media. But primarily it was just putting in document after document after document. But the defense, and I think Goering did very much trying to foster this belief, because Goering knew he was going to die. He was going to use this as a platform to justify that the Nazis, or show, them in a more positive light. And the premise for him was, this is just Victor's judgment. I mean, you're going to hang us, and this is all a bunch of stuff. It doesn't mean anything. The verdict is predetermined, and we're all going to die. One of the neat things I think about this trial that proves its legitimacy is that several of the defendants were acquitted, but some of them got lighter sentences. So they were able, maybe they just didn't all march them out and hang them. Then they distinguished and said, no, this person doesn't fit into that conspiratorial charge, and so they found him not guilty.
Were any of them of the primary group of roughly 21, 24 people? Some of them were found not guilty.
Yes. Yeah. There was some the banker, maybe. I'm drinking my memory here, and Fritcher, the public announcer, the one who just did announcing on the radio. Now Hess was not found guilty of the war crimes and the concentration camps, and because he left Germany in 1941 when he took a plane to England with this plan for peace with England, and then he was locked up in England. Now the Hess part of this case is fascinating if you're a trial lawyer. His defendants were basically saying he's got locked in La La Land. He's gaga. He can't defend himself. He's out of it. He got amnesia, and he's all this, incapable of defending himself. Not an uncommon defense in this country. During the argument of his counsel, a note comes up from Hess to counsel saying, I want to talk. I want to say something. Well, okay. So Hess stands up and he says, I've been faking this all along. I really do understand what's going on, and I want to be tried with my colleagues. But to Hess's benefit, he says, I did what my counsel didn't know this. I played this game with my counsel as well. So he is not complicit in this. And it's I was putting on this act, and I'm ready to stand trial, and that. So the speculation with regard to Hess is he had a talk with the resident psychiatrist that was assigned to this prison, who ended up talking to all these defendants and wrote a very good book about it. And the speculation is, in talking with him, the psychiatrist says, if you win on this defense, you're going to spend the rest of your life in an insane asylum. So I mean, it isn't like you're going to escape anything. You're going to spend. So I guess maybe he decided to take his chances with the group.
I didn't read this, but was there any sense, I got this from Goering. Goering testified,
Yes,
and he was cross-examined.
right.
And it's my understanding from what I read that he was very matter of fact. He had no aversion to telling what he did, but he, in different ways, tried to justify it. And I gather that Jackson may have had some difficulty getting to him at first, but eventually did. If that's at all, and you can correct me if I'm wrong, but
that's tracks what happened exactly right. And this is one of the areas where Justice Jackson was very much criticized, was the cross-examination of Goering. But to step back a sense, as a trial, what he's trying to do with Goering is basically going to admit everything. Oh, we did that. Yeah, we did that. We did that, and we abolished this, and we did that. If you're trying a case in front of a jury, right, you would say, go ahead, or even for historical reasons. I mean, he's basically admitting everything. So why not let him do it? Except that he then, got to use it as a platform to espouse, again, Nazi propaganda. So then Jackson tried to do what Americans do in cross-examination, and that is to ask questions and then limit the answers. Saying, oh, well, you can go on that and redirect. Your counsel can bring that up. You've answered it. Done. Well, the British judges who was presiding, they have a different view in the British system, a little bit about cross-examination. They allow witnesses to expound on their answers.
tell their story.
Tell their story or get that in. And the British barristers are used to that, and they make use of that. I mean, in fact, when I was working with barristers trying criminal cases, even if if a witness would have that opportunity, you always say, don't say anything else. Just answer the question, yes or no. If you add something, you're just giving more grist to the middle. Don't do that. So, but Goering was looking for history. I mean, he was going to want to go down as one of the great Nazi leaders, and I supported Hitler all the way, and so that was his goal. And so Jackson got really angry as he got, and had this set to with the judges, and so that has been one of the things that has dinged Jackson's reputation. I think it's a little unfair because, again, who is his audience? He's not just trying to try this case in front of a tribunal. He's trying to establish it for history. And you have a witness who basically will say, yeah, we did all these things. We got rid of the parties. We don't need the Reichstag anymore. They were just trouble. And so, he did all that. And so I sympathize with Jackson in that regard.
I read where Jackson later in the examination made some headway with him, and that Goering, at some point, it was characterized, this one author said that Goering realized that no matter what he said, he knew what the outcome was going to be. Not that it was just preordained because of the general nature of it, but because eventually Jackson was able to bring out a number of points that he could not rebut. Before you answer my question, I was wondering whether Hess's testimony, and this is what I started to say earlier, Hess's testimony where he admitted that he was making this all up initially, his mental condition and so forth, whether Hess testified before or after Goering, if you recall, because I wondered if they decided at some point there was some honor in hanging together.
Well, Hess never really testified as much.
Oh, okay.
I mean, this was just a statement he made from the jury box.
I see. Okay.
And so some of them testified Morgan Spear, Donitz, and other ones testified. And so Goering, Jackson, I don't think that now the movie Nuremberg has Jackson do an outstanding job, comes back into the courtroom with Goering and just rips him apart. That didn't happen.
I'm not basing my comments on that, just some other research.
But I mean, he did better. It was the British prosecutor that did a real good job on Goering, but it was for different crimes. It was for murder of war prisoners. I mean, and he focused on that. But again, he knew how to cross-examine him better. And again, under American system, you could say, you've answered my question. You can, if you want an explanation, you wait for your counsel to give it, give an explanation. And American judges would often say yes, to that, but British judges didn't. So in the end, most of them were convicted. Most of them were hung, and so.
In our last 5 minutes, by the way, I'm sorry I didn't give you further.
Oh, okay.
No, please go right ahead.
Well, I mean, more questions. I'd love questions.
And no calls have come in.
Okay. And no more. Jeff, did you have any other specific questions you?
Oh no, go on. You started to say in the end, your time.
Well, in the end, they, after 10 months, most of them were convicted, and they were hung. Now, Goering didn't, because somehow a cyanide pill was secreted into him as a cell, and he committed suicide with cyanide. There is the movie, and some historians try to think it was this guard, that it's his guard that did it, and I think that's been pretty well debunked. But Goering was very charming. I mean, he was a charming guy. I mean, he really did charm his jailers in some respect, he could have been the case, but I think more likely his wife had visiting privileges, probably brought the cyanide tablet to him. So he ended up thwarting justice, and they really wanted to hang Goering. That really ticked off the warden of the prison that happened on his watch.
Oh, I'm tempted to say that he was willing to take center stage to tell his story, but didn't want to hang around for the hanging.
Oh, good pun, Jeff. Good pun.
Yeah. Well, but I guess he wanted to make a statement by that also.
And the military men fought to be shot, but didn't win that argument either. So they weren't going to get the honor of being shot.
Yeah. One author said that Goering famously was a brain with no conscience.
I would say that most of them had conscience. I think the psychiatrist's conclusion about having talked with all these people, I mean, just think he had insight. He talked to these people all the time. He said lack of empathy. That is what he thought was evil.
Yeah.
Is no empathy in these folks. They had absolutely no empathy at all. And therefore, that's the face of evil to his mind.
Yeah, I read one account that said that Goering's view of things was that they had a plan, they knew what they wanted to do under the Reich, and the killing of millions and millions of people, 6 million Jews and more, was necessary for them to put down any type of defense that might have been offered against them by the people. But one of the premises for arrest was not that you committed a crime, but you were a person who was likely to commit a crime in their mind. So all the communists got rounded up because, well, we must know the communists are going to commit crimes eventually, so we just round them up now. And
that. So
You're going to be in our way. You're going to question what we've set out to do. And so we just have to get rid of you.
yeah.
Hitler may have hated the Jews, and Hitler may have had a long-standing position on that, but some of these others, I just wonder. It was like the old saying, it's business. It's just business.
Yeah.
It's a cold lack of empathy that you talk.
Oh, absolutely. I was going to show you the testimony of Haas. Kaltenberger called the commandant for Auschwitz to be a witness on his behalf. Now, can you imagine calling? And it is the most, and it was verbatim. If you watch anything from the Nuremberg case, watch his testimony. It is absolutely chilling.
I want to thank you, Dennis, for being with us this evening, and I hope you'll come back again. And whether it's on this topic or another one, you keep doing research, and I'll keep in touch.
All right, that sounds great to me, Jeff. Thank you so much.
Okay, thank you very much.
All right, bye-bye.
Happy, healthy holidays to you and all watching the show. Good night.